I don't really understand in good faith how you can say, if you're a Catholic organization, we expect you to only serve Catholics when you minister. And if you do this thing where you serve whoever comes to your door, like the way Christ did, that you're not a religious employer in this case, or that you don't get a religious exemption. You're not primarily operating for religious purposes in the Wisconsin Catholic Charities case. That's a crazy distinction to make. I don't know why that's what makes you religious under any coherent law. Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. So this week, we're going back to the Supreme Court, and this is a very federal kind of issue. So we're going to start with the end of the Diocese of Albany versus Harris case, which we've covered in the past. Then we'll talk about a petition to the Supreme Court that, if granted, would have pretty important impact on church autonomy, First Amendment precedent. And then finally, we'll talk about a dispute over abortion referral mandates between Health and Human Services and the state of Illinois. So let's start with the New York case that is now over. So this has gone, it's a long saga. We've discussed it before. It's actually been at the Supreme Court twice. Let's give a little backdrop in case people don't remember this. This is the decade-long now effort to basically force all employers in New York, including many groups of churches, nuns, and so on, to pay for abortion in their insurance policies. So New York has had this abortion mandate in its employer requirements since 2017. So it requires employers to cover abortions in their employees' health insurance policies. The mandate did include a religious exemption, but that was narrowed by, I believe it was just by the regulations in New York, only for those that primarily teach religion and only for those that serve or employ only those of their own faith. We'll get into the actual language of the regulation at the end, because I think it's really important considering the state of Establishment Clause jurisprudence after the Wisconsin Catholic Charities case. So we'll get back to that. So now, many years ago now, a group of religious organizations, it was interdenominational. There were Catholic nuns. There was a group of Anglican nuns. There were some Catholic dioceses that were all subject to this mandate, challenged the state's law and the narrowness of the religious exemption in the case of Albany, Diocese of Albany versus Harris. So the New York courts were continually ruling against the religious organizations, even after the first Supreme Court intervention. So the first time the case went up to the Supreme Court vacated the New York court's decision and remanded for consideration in light of Fulton versus City of Philadelphia, which you'll probably remember is the case that ruled that the Catholic organizations could not be excluded from the foster care contracts regime in Pennsylvania because of their views on marriage and same-sex relationships and adoption and foster care. So Supreme Court sent it back down, said reconsider this case in light of Fulton. New York continued to reconsider the case and find that Fulton didn't apply. And so it went back up to the Supreme Court because the nuns and the dioceses were still being pushed with this abortion mandate. And so last year, the case went up to the Supreme Court again. They granted cert and said same thing, but with a different case citation, right? So decision of the New York court is vacated, remanded to be reconsidered in light of Catholic Charities versus Wisconsin. Now, this one was, for those who remember, which again is probably everyone listening to this, the Wisconsin Catholic Charities case is so on point and so relevant. I mean, more than relevant. It's almost the same set of facts in a different situation. That it would, my prediction back when Wisconsin Catholic Charities came down in this case was there's really no way for New York to get around or distinguish Wisconsin Catholic Charities. So unless they amend their law and the religious exemption in particular, that should be the end of this case for the Diocese of Albany and the poor sisters involved in this. So just recently, the state of New York agreed to exempt the religious organizations from the abortion mandate to settle this case and end the about a decade almost of litigation now, which would ensure that the churches and the faith-based nonprofits that brought the case are now free to live out their beliefs, to not provide abortion coverage in their healthcare policies, and to be finally left alone and free to do their religious work without being involved in this court battle. So I just want to touch briefly on a couple things. On one hand, of course, this is a victory, right? Wisconsin Catholic Charities said you're not allowed to discriminate like this in the way that you give religious exemptions. And so it's good to see that that Wisconsin Catholic Charities case was actually applied and ended this case, right? So just a reminder, right? Wisconsin Catholic Charities basically said they're defining religion in a statute, like in a statutory exemption, to include some types of religious entities or decisions, but not others. And when those distinctions are actually based on doctrinal issues within those religious organizations. So in the Wisconsin Catholic Charities case, right, the exemption was given only to religious organizations that proselytize, that try to convert people to their religion, or that only serve members of their own religion in their ministries. And what the unanimous Supreme Court decision said in Wisconsin Catholic Charities is, listen, you're making a distinction on who gets a religious exemption and who doesn't based on doctrinal beliefs, right? Whether they proselytize heavily or whether they're more hands off in their evangelizing efforts, whether a religious organization chooses to serve all comers or only fellow co religionists, those are doctrinal issues. And so for a government agency to make, or a law in this, or a regulation to make distinctions and say you get the religious exemption, but you don't, based on doctrinal issues, is an establishment clause problem. So that was unanimous by the U.S. Supreme Court. And there's no way around this logic applying to Diocese of Albany versus Harris. I mean, and now I want to find here it is. The New York regulation, so it defines religious employer and says that religious employers are exempt from this abortion mandate. Good, right? But in order to be defined as a religious employer under the New York regulations, a religious employer only applies to an entity for which each of the following is true. The inculcation of religious values is the purpose of the entity. The entity primarily employs persons who share the religious tenets of the entity, and the entity serves primarily persons who share the religious tenets of the entity, and then they have to be a 501c3 nonprofit. So these requirements that to be a religious employer and to get these exemptions, that you primarily employ persons who share religious beliefs, that you primarily serve persons who share the religious beliefs of the entity, these are the same establishment clause problems that the court said no to in Wisconsin Catholic Charities, right? There's just really no way around that. You're distinguishing and saying the only ones who get the benefit of a religious entity are the ones who, right, only serve co-religionists, which is very mysterious, by the way. I don't really understand in good faith how you can say, if you're a Catholic organization, we expect you to only serve Catholics when you minister. And if you do this thing where you serve whoever comes to your door, like the way Christ did, um, that you're not a religious employer in this case, or that you're not a religious, you don't get a religious exemption. You're not primarily operating for religious purposes in the Wisconsin Catholic Charities case. That's a crazy distinction to make. I don't know why that's what makes you religious under any coherent law. The only, again, you don't want to ever assume bad faith, but it looks to me like this is something that is intentionally put out because it then causes trouble and puts this abortion mandate on certain types of religious organizations, right? Anybody making laws knows that pro-life pregnancy centers or religious sisters that work with pre-abort, like with pregnant or post-abortive women, of course they're taking all comers. Of course they're not only helping pregnant women who share their same religion, it's whoever comes in the door. That should be laudable. The fact that they're particularly targeting these groups and saying like, yeah, you don't get the religious exemption, is kind of crazy. So again, if it's not obvious, the New York regulation to me is almost identical in the way that it impermissibly makes distinctions on what is and is not religious, almost indistinguishable from the Wisconsin Catholic Charities law that was unanimously struck down. Great. So as I had predicted several months ago, this would be the end of this Diocese of Albany versus Harris case. But the one caveat or thing to remember is this case ended in a settlement. So what it means is that the parties, right, the churches, the religious organizations who sued New York, they'll be treated as religious employers for purpose of the abortion coverage mandate, right? They will not be forced to provide abortions in their insurance plans, but it only applies to I think it's 8 or 9 plaintiffs that are left. A few of them have backed out because it was moot, didn't apply to them anymore. But anyway, as far as I can see, the regulation itself remains on the books, right? So a settlement between parties doesn't create precedent and it doesn't repeal a regulation or a statute. So That being said, I do want to make clear that with this settlement and with the Wisconsin Catholic Charities precedent looming, I think it would be extremely difficult for New York to take another religious organization who is not a plaintiff in the Albany versus Harris case, and say, no, no, like that you don't serve all, you don't serve only co-religionists. You're a new religious organization. You weren't part of that lawsuit. This abortion coverage mandate still applies to you. I think that would be both in terms of media coverage and legal precedent would be pretty hard to get away with, but it is still possible, right? If as long as a law is still on the books, it hasn't been struck down or repealed, um, it's still there. So I'll leave it at that. I think obviously this is a win for the parties at play. Obviously, it sets the precedent that Wisconsin Catholic Charities does make it impermissible to have these kind of pick and choose religious exemptions in state laws, but the law is still there. It's still on the books, and it's just important to make that clear. So, Joseph, anything you'd like to add on this case?
Yeah, Frank, you really covered the core legal and even cultural questions here. Really, I just want to take a moment to say props to the sisters, dioceses, and churches that fought this battle in Albany v. Harris. Not many people would be willing to go through, a decade of complex back and forth litigation, losing several times at lower courts, going to the Supreme Court twice. It's a really arduous and long process. Here we have just some ordinary people that are trying to live out their vocations. They ran into something that interfered with that, so they fought it. In a recent episode with Andrea Pacioli-Bayer, we talked about using these kind of disputes as moments of evangelization. And that's what happened here, right? We have these nuns and other religious leaders stood up for what they believed in, stayed true to their faith, even when they weren't sure how it ended. So using these chances to say, this is why we're against abortion, this is why we're against providing for it in any sense, and we're not going to bend on this, even if it takes 10 years of fights in the courts. So really just props to everyone that fought this battle and endured um, this really arduous process, and they serve as a great example of how to use challenges to your beliefs as opportunities to share them. So with that, we'll move into our second update, where we're going to discuss a recent cert petition that's getting some attention in amici, where a church in California asked the Supreme Court to overturn its $1 million fine for violating restrictions imposed on the church during COVID. So, for the facts, during COVID-19, a county in California called Santa Clara County imposed several requirements on all businesses, which included churches. Basically, individuals attending worship services had to wear face masks, remain certain distances apart, limit how many people were in attendance, follow these other protocols. I think they weren't allowed to sing, that kind of thing. And there were exceptions from the requirements for secular activity, like for people at a gym or in sports competitions, for people receiving medical care. It said basically if you're getting plastic surgery where you have to take off your mask, then you're allowed to take it off. And lots of other kind of just different secular activity that has exemptions to these masking and other requirements. Religious organizations notably offered no such exceptions. It applied across the board. Now, based on its beliefs, this Protestant church called Calvary Chapel San Jose refused to follow the requirements during their services, and because they refused to do so, they were fined over $1 million. Initially, the state sought over $3 million. We were talking offline about how we're not really sure how these numbers are produced, but some pretty astronomical numbers that we're dealing with here. After losing a couple appeals in state court, the church ultimately recently asked the Supreme Court to hear their case. Now, the facts themselves are probably pretty familiar to a lot of our listeners. There's been a lot of litigation against unjust state restrictions imposed during COVID. One of the first was Diocese of Brooklyn v. Cuomo, where the Supreme Court ultimately ruled in favor of some churches that challenged New York's restrictions that limited attendance at worship services, which granted exceptions to similar secular activities. The kind of landmark case, Tandy v. Newsom, where the court decided against restrictions like this in California and ruled that even under the Smith precedent, government regulations like these that treat secular activity more favorable than comparable religious activity are subject to strict scrutiny, and they ultimately ruled against them. So the facts themselves look a little bit similar. There's been a lot of litigation around these sorts of things. But one of the questions presented in this case is novel and is worth spending some time on. So there's a couple big things in the questions presented, but the kind of novel and potentially most impactful one is Q2, where basically the petitioners are asking the court to expand the Church Autonomy Doctrine by recognizing a liturgical exception in addition to the already established ministerial exception. So there's the mouthful. A lot of people are probably already familiar with this, but I'll spend a brief moment to run through church autonomy, the ministerial exception, and what's actually being asked in this case. So, church autonomy doctrine has been recognized as part of the First Amendment's religion clauses really for decades, dating back to at least the 1950s with Kedroff. And the concept under church autonomy doctrine is that when deciding on matters of faith and doctrine, religious organizations are free to do so without government interference. Basically, civil courts don't have jurisdiction in religious matters. That's not what they exist to do. That's not where they really have their reach. Under the church autonomy, there's this concept of the ministerial exception, which has been recognized a bit more recently and expanded in the last couple of years. And the ministerial exception says that religious organizations have near absolute discretion when they're hiring or firing ministers, regardless of whatever state or federal non discrimination law. The famous example in Our Lady of Guadalupe was that a religious school can basically take age or other factors into account, regardless of state laws prohibiting that when they're hiring religion teachers that were deemed to be ministers. So basically, church autonomy gives um, kind of a broad capability of churches to decide on their own matters of faith and doctrine. Ministerial exception is a part of that, which says that it extends to the hiring and firing of ministers, and you have pretty broad discretion regardless of existing laws. So, what is this proposed liturgical exception? And as far as I'm aware, it's a novel request. It's not really been recognized anywhere before. They actually, in the cert petition, they said the lower courts didn't have the leeway to recognize this new thing, so they're asking the Supreme Court to. And basically, here, Calvary Chapel is arguing that the state imposed restrictions on its liturgy. Like you can only have so many people in attendance, you have to wear face coverings, X, Y, and Z, that would be imposed during their actual worship and liturgical activities. Um, and they're saying that, however, the manner in which a church conducts its liturgy is an internal decision based on its faith and doctrine. They're saying that liturgy is an essential and internal part of a religious organization's mission that is at least on par with the hiring of ministers. Just to read briefly a sentence from the cert petition, the church and its attorneys say that, indeed, if anything qualifies as, quote, essential to the institution's central mission, end quote, and that's the language from Our Lady of Guadalupe, it is the conduct of worship itself. Just more broadly and generally speaking, the attorneys also argue that the very spirit of the American experiment in the Constitution renders anathema the notion of government refereeing the conduct of religious services. Freedom from unjust government has been central to the American mission since our nation's founding, and a crucial part of that freedom is to worship according to one's own beliefs. In fact, even in the very early American history, many of the state declarations of rights from the 18th century recognize explicitly the right to worship God or the Creator in accordance with one's own conscience. So this is really part of the American DNA, is this basic freedom to worship as you believe with your religion. So here, the liturgical exception is basically saying that we already have recognized church autonomy in the First Amendment. If we say that you have pretty broad discretion to hire ministers, why is it any different for liturgy, which is just as, if not more essential and internal based on faith and doctrine to a religious organization's identity? Practically speaking, a liturgical exception would mean that any government activity that dictates the manner in which a liturgical practice can be conducted um, could be overturned in court. For example, currently Virginia law states that any government restrictions imposed on churches during a state of emergency can't be more restrictive than the restrictions imposed on secular organizations. That's basically the logic from Tandon, right? You can't say churches have more restrictions than secular organizations. Um, under a liturgical exception, really regardless of the other restrictions on comparable secular activity, only the restrictions on religious activity could still be struck down if this liturgical exception is ultimately recognized and promulgated by the court. There are lots of other parts of this cert petition that I like. For instance, they're also claiming that $1 million fine for basically they did this religious conduct that they thought was going to be protected. They did it in good faith, that's excessive in violation of the Eighth Amendment. They're saying that there's not really a clear jurisprudence on how to decide when a fine against a church based on its religious beliefs is excessive, and that this is kind of an opportunity to do so. There's lots of really fun and passionate language about how these sorts of restrictions belong in Soviet Russia or communist China, but not in a free America. So it's a very passionate and kind of patriotic cert petition. And they're also asking the court to either cabin or overturn Smith, which is always fun to read about and see presented before the court. So regardless of whether or not the court takes it up, Frank and I were talking offline about we're not totally sure how kind of Supreme Courtable this case is. But regardless if it gets taken, I'd encourage our listeners to read the cert petition, learn a little bit more about this potential expansion to church autonomy. So Frank, there's more I could say on this, but I'd love to hear your thoughts.
Yeah, I think this is kind of a wait and see for us because, for one, I'm a little bit pessimistic about the odds of it being taken up. Like you said, there's not a circuit split. It doesn't. I mean, you never know what the Supreme Court's going to do. I'm no Supreme Court whisperer, and I don't want to make predictions, but I think I'd be a little surprised if this one gets picked up. But who knows? And the other thing that I think I'll just take a shot at, and this is based more on like my knee jerk kind of gut reaction to this claim. Um, I'm I'm not sure how far I follow the liturgical exception, like what's being argued here. I definitely can, but and again, this is just my like first look at it with this case going up on cert petition. But this argument that the restrictions on the liturgy are restrictions on something that's basically that falls under the Church Autonomy Doctrine, right? Like all of these decisions are internal decisions about worship within an organization. So I buy it to a certain extent, but what I'm thinking of here is like, for example, we were just talking about the Ninth Circuit case, was it last week or the week before, where Judge Bumate wrote the opinion arguing that the decision to employ only co-religionists, right? Only those who believe the same thing for a religious organization, even if they're not ministers, falls under church autonomy, but only if it's made for a religious reason, right? Like just because they're um yeah, just because the organization is a religious organization doesn't mean that they can say like, "No, sorry, janitor, we're a religious organization, and as a matter of church autonomy, I don't like your face, and you're not going to work here." Right? Like that's not covered. It has to be for a religious reason. So I guess that's I'm wondering how that would be applied here in the liturgical exception. Again, I haven't read the cert petition in any depth at all here. I just glanced. So but I think that I would make distinctions that like on one hand, I think you have a stronger argument with things like, okay, the restriction of singing, right? Like that actually is a question of worship, right? You have certain liturgical traditions, like within Catholicism, a lot of the Eastern rites, like the whole liturgy is sung. So restricting singing and saying, well, because COVID, you can't sing. I think that's a stronger case for church autonomy. Like there is a real bona fide religious reason that you can't be interfering in whether they sing. But then when you start getting into like how far apart people stand, how many are in attendance. I'm not saying government should have any say over this happening in churches, but I think you have a harder argument that you have a religious reason within, governing the liturgical decision. Like, no, we have an internal religious doctrine that says that we can't wear masks when we worship, or I don't know, maybe you need to hold hands during certain parts of the prayers. I don't know. I can't speak for every denomination and their religious beliefs, but I guess I would just probably say that I think some of these claims are going to be stronger than others, whether they're like bona fide religious versus, political or scientific or medical disagreements, which I would agree with, by the way. But I think I'll probably stop there. I want to see where this case goes, and I would, if cert is granted, obviously we'll be reading a lot more in depth to seeing where these arguments go. All right, last case we'll move over to this HHS Office of Civil Rights letter that was sent to Illinois just recently, and this is over abortion referral requirements under Illinois law. So this is it's an interesting one. I read through the letter that OCR is Office of Civil Rights. Many agencies have one, but this is the Health and Human Services Office of Civil Rights. So if I say OCR, that's who I'm talking about. It's the letter is very complex at first glance, a lot of legal precedents and things intertwined, a lot of citations to different laws and regs. But it is actually fairly simple. So we'll make short work of this, I think. So basically, Illinois law, as the healthcare law was recent, well, not too recently, but has been amended. Um, Requires healthcare providers who refuse to perform abortions to refer patients to another provider that will, or give them information about where they can go and receive an abortion. So there's a challenge to this abortion referral requirement currently pending before the Seventh Circuit. But in the meantime, this is something that Health and Human Services, Office of Civil Rights will regularly investigate because HHS money is flowing to these states in their healthcare programs. So very much something that Office of Civil Rights at the federal level will be looking at. And lawyers from several places, including Alliance Defending Freedom, have sent letters to HHS asking them to investigate this matter. And then recently, OCR just issued a letter to Governor Pritzker and other officials in Illinois stating that it is a violation of current federal law to require abortion referrals. So the letter states points to a couple of federal laws in particular, the Weldon Amendment and the Coates Snow Amendment, that prevent discrimination against those who refuse to refer or perform abortions. And it is very clear, those amendments, that you can't discriminate not only against those who won't perform abortions, but those who won't refer for them. So again, I read through the letter in depth. It's very comprehensive. But when you cut down to it, here's the very simple conflict. So the Illinois state law requires that anybody who objects to abortion, right, these will be religious doctors or medical personnel, if they object to providing abortions, they are required to adopt written access to care and information protocols, and to ensure that those protocols that the objecting medical establishments make require that those protocols require an objecting doctor or an objecting facility to provide a referral, a transfer, or information about where an abortion can be obtained. That's the state law in Illinois, saying, okay, you can object to giving an abortion, but you have to tell them where to go, what to do if they want one. So contrast this to the federal laws that OCR's letter cites, and they are, I think, very clearly at odds. So the letter, I'm reading from it here, the Weldon Amendment states in relevant part, none of the funds made available in this act may be made available to a state or local government, that's Illinois, if such government subjects any institutional or individual healthcare entity to discrimination on the basis that the healthcare entity does not provide, pay for, provide coverage of, or refer for abortions. Okay. Code Snow Amendment, the federal government and any state or local government that receives federal financial assistance may not subject any healthcare entity to discrimination on the basis that the entity refuses to perform induced abortions or to provide referrals for such abortions, or the entity refuses to make arrangements for any of the activities specified in paragraph 1. So the letter goes on to tell Illinois that based on the plain language of the Weldon and Coates Snow amendments, Illinois is prohibited from discriminating against a healthcare entity on the basis that the entity does not refer for abortions or make arrangements for abortion or referral for abortion. So I don't want to go on because I think it's fairly clear. This is one of those cases where yes, states can legislate and do a lot of things where the federal government doesn't have a say, but we have this very elaborate funding structure in our country, for better and for worse, a lot of the time, I think, where federal tax dollars are collected and then flow down to state and local governments through grant programs and funding of all sorts of things. So, be that as it may, it is a reality. Whether it's good is a separate issue. But HHS gives a ton of money for things like medical care at the state level. And so, pretty much all hospital networks, doctor networks that you're going to see at the state level are in fact and the state agencies that oversee these things, right, state departments of health and so on, are receiving HHS money, and so they're very much subject to federal law because they receive federal money. So in this, it looks pretty clear. Illinois says no, if an objecting doctor is for religious reasons or what have you is not going to perform an abortion, he must give information, he must give referrals, he must give transportation, transfer rather, to a facility that will do so. And federal law says no, you can't discriminate against doctors who, if you're receiving federal money, and you can't make them give referrals. So that's basically it. Illinois is not allowed to require referrals from objectors to abortion as long as they receive federal funding. Illinois both receives federal funding and is in conflict with federal law, and so we'll see how this escalates. We've seen a lot of other areas where states hostile to the Trump administration are quite in conflict. If you're watching the news these days, you're seeing that in the immigration enforcement area. So who knows? Who knows whether this is something where Illinois will back off, if this is going to have to proceed in further court proceedings. But for now, there is very much conflict between federal law as the current administration's HHS interprets it, and I think by the plain meaning of it, and what Illinois is doing. So.
Yeah, absolutely, Frank. Thanks for explaining what's going on here. And I just want to add a little bit about how we've discussed a related kind of deeper point going on here on this podcast with other Tad Maholchik from NCBC. And in that, he really stressed the point that medical conscience rights include refusing to perform referrals for things like abortions when you find them objectionable. The main reason is that requiring someone to be part of the causal chain that leads to a wrong act forces them to have a hand in the act itself, right? Requiring a doctor who says that, or requiring a doctor to say that I won't perform this abortion for you, but here's exactly where you can go, and this is the guy's name, and this is where it's located, and all these specific details. And then that person goes and gets an abortion solely based on the information you've provided. That doctor is now a link in the chain that directly led to the killing of an innocent human life. And I do just want to use this too as an opportunity to highlight something else similar going on that we haven't really talked about yet on this podcast, very briefly. And really, right now, there's a lot going on about state battles between states over mail-in abortion pills. Basically, there's a lot going on right now between Texas and New York and between California and Louisiana. And what's happening is that doctors in states with very lax abortion laws are mailing abortion pills to women in states that ban doing so. And then those states that ban abortion are starting to say, hey, we have these bans. You can't kind of get mifepristone and these other terrible things into our state. So like in Texas, a New York doctor mailed an abortion pill to a woman there. The same happened from a California doctor to somebody in Louisiana. And there's these ongoing fights in the courts about whether the doctors that mailed the abortion pills can face penalties under the state's laws that ban the practice. Where we have states like Texas and Louisiana are trying to make that chain of events that leads to an abortion like this, at least in most circumstances, impossible. And we haven't addressed these disputes going on right now because it's kind of still murky. There's a lot of back and forth, a lot of still kind of legal posturing about who can bring what suit, who's going to be liable for what. So we're waiting a little bit more to see what happens there. But really, I just want to take this as a point to highlight what's going on and to say basically stay tuned, keep you guys updated as this continues to play out.
Yeah, there are a lot of stay tuned cases in this week's episode. So we will keep on top of these and we'll keep you updated as things progress. And with that, we thank you for joining us for this episode of the Napa Legal Podcast. If you enjoy the content that we're putting out, we appreciate it if you like this podcast and subscribe to our channel on YouTube, Spotify, or wherever you're listening from. If you want to learn more about what Napa Legal is doing and if you'd like to support us, we always appreciate that. You can visit our website at napalegalinstitute.org and find out what we're up to. We hope you'll join us next week as we continue to highlight and discuss the most important ongoing legal issues that affect religious freedom and the work of faith-based nonprofit organizations. We'll talk to you next week. Thanks for joining us, and God bless you all.